Sanchez, and welcome to Sonoma Views, where we talk about real estate, property management, restaurants, what's going on in Sonoma County, and everything in between. Thank you very much for being here. On the property management side, today's topic is how to deal with tenants who violate their lease. And it could be for a number of things, but if you have tenants under a residential lease, how do you deal with tenants who are not living up to their responsibilities, their end of the lease? And it can be for a number of reasons. For example, noise disturbance. If neighbors complain about the tenants, if the police are called out, if I'm just trying to think, if they're made a mess of the place, or they have junk cars and just a whole slew of potential things that the tenant could be in violation for. So first and foremost, it's what is in your rental agreement. So that is sort of the law, if you will. That's the governing document between landlord and tenant. Hopefully you have a written agreement and it's signed by both parties between landlord and tenant. There are unfortunately a lot of rentals out there where it's just the tenants moved in based on a verbal agreement, and sometimes friends rent to friends or family members, and that happens, and there is no formal rental agreement and they just take it day by day. So I highly encourage anyone who even between friends and family, that there's a written rental agreement so that both parties have a clear understanding of what their responsibilities are. It's just good practice. It avoids understandings. But in a normal circumstance, as a landlord has a rental agreement, whether it be a month-to-month or it be a lease, and the tenant has certain responsibilities, certain obligations. Within that lease agreement, there are restrictions, there are limitations, and there are responsibilities that the tenant must hold up to, they must adhere to. As an example, recently I just got a complaint about one of our tenants who are being loud, and they're causing a disturbance and a nuisance for the neighborhood. All right, so it all comes down to two main points. What is written in your rental agreement regarding those items? That's the first thing you do. What does the lease say? As an example, my lease states, just off the top of my head here, I'm on the way to the office, tenants cannot play excessively loud music. They cannot have parties of 8-10 people or more. So especially the raging parties. If the police are called out for a noise disturbance, that's a major violation. Some of the common ones are smoking. There is no smoking on the property and in rental units. So no smoking whatsoever. It's written in the lease agreement like 3 different times. Tenants are 100% wholly responsible for any damages or any cost of smoke remediation, smoke removal, odor removal. Keeping the place clean, sanitary, free of debris. So that means don't pile up trash bags, don't pile up recycling containers. It attracts rodents, it attracts ants. It's unsanitary. It could attract roaches. Don't have junk cars on the property. Cannot use the residential unit for a business, commerce, childcare facility. Cannot sublease, cannot bring in other people, move them in or move them out without the landlord or manager's approval, etc. As you can see, you can't make alterations or improvements to the property without approval. You can't just decide to go and paint the entire place pink or blue, or install a satellite dish. There's rules in there for a purpose. There's always a reason why they're in there. So if a tenant violates one of those things, then the big obvious one, paying rent on time when it's due. If they do not pay the rent on the due date or within your grace period, then they will get a late charge. And if there's a bounce check, they should have a NSF, a non-sufficient funds return check fee. And all these, policies and procedures are built in. The terms are built into the lease agreement, so it's already planned out in advance. If something happens, what is the consequence? All right. So, what if a tenant does do one of those? They violate a term of the lease agreement. Depends. You have two different ways of approaching it. The first one could be a verbal warning, and that might nip it in the bud. And depending on the relationship, if they're good, responsible tenants, but they either did something that they didn't know about, or they intentionally violated one of the terms of the lease, you might be able to nip it in the bud simply with a phone call, a courtesy phone call. Hey, I want to bring this to your attention. The neighbor called, complained about this. This is a verbal warning, and that's it. This stuff needs to stop, and the next one will be a written violation. So that's one approach that you could do. That's it's a more courteous way of going, and it's respectful to the tenants. I'm sure the tenants will respect it, because then they're not getting an official legal notice, which is good on that, from that perspective. However, the tenants are not your friends. More than likely, they're not your friends. It is a business. They have a certain amount of agreements, and that lease agreement is the enforcer. And so that's an agreement. You should be able to enforce those items that they had already agreed to. So taking it a step further, other than just a verbal warning, what I do, what my office does, we give a written notice right away. It's just, they're not going to like it. If you call them and bring it to their attention, they'll appreciate the verbal notice, but they're not going to like it, because you're already telling them that, hey, you violated a part of your lease. So what we do is post a written notice. So we want to create a record and make that part of the file. Hey, you were smoking, or you were loud, and you give them a written notice regarding the violation. They violated a part of their lease. And the way to do that, we use a 3-day notice to cure. And it's similar to a 3-day notice to pay rent or quit, but it's a different notice. It's a 3-day notice to cure a violation within their lease, because it's a breach of contract. The 3-day notice to quit or perform covenant, excuse me, smoking as an example. Tenant, property address, you hereby notified that you caused a violation within the terms of your lease according to page number 2, line item 10, subparagraph, etc. Put the exact wording within it. All residential rental units are non-smoking. Tenant shall not smoke on the premises, etc. So you state the violation. This is their violation. Within 3 days, then you give them the corrective action, what they're supposed to do next. And so it says, okay, you're smoking as an example. Here's your violation. Here's what the lease says. Here's what you violated. You were smoking on the premises. We received complaints from a neighbor, which is a separate violation in itself. Creating a disturbance or a nuisance to a neighbor, that's a violation in itself. So your action to be taken is immediately stop or cease the noise disturbances, nuisances to neighbors, stop smoking, or an example would be overgrown landscaping. According to the lease agreement, tenant is responsible for all landscape maintenance, exterior landscape maintenance, and keeping the property clean and free of debris. And so that would be in the lease agreement. Your violation is the landscaping is overgrown, you have not maintained it. Or sometimes the city code enforcement will go out and say, hey, this is an eyesore, this thing, according to the city ordinance, you're supposed to have the grass cut, the vegetation cleared back from the house. They're looking for fire hazards as well. Or it could be the fire department that says, hey, you have a violation. So yeah, at that point it's a real violation. So here's what the lease says. Here is your violation. and then within 3 days, or you set the specific amount of time to cure that violation, to make that corrective action. So within 3 days or within 1 week, you must do a full landscape maintenance, clear back vegetation according to the terms of your lease, and restoring it back to reasonable original condition from the time that they moved in. Within 3 days. Failure to do this may result in further legal action, which would be they made a violation, breach of contract. You gave them the amount of time to make the correction. If they do not do it, then you can take further action to help enforce the terms of the lease, and start the eviction process, which is a legal battle. You may or may not want to go down that road, but by posting this notice, it is a legal notice. Now, furthermore, we charge a $50 legal notice fee, and that's written into the lease agreement. If myself or one of the folks in our office has to go, and we don't just mail this out, we actually post it on the front door, legal service, post it on the door and mail it, posted mail, or nail it mail, which is a slang term. Post a notice on the door and mail it out, and sometimes we may even email it as well, so that there is no confusion, that there's no dispute that we delivered that notice in writing to the tenant and gave them proper notice and the proper time to make that corrective action. So where do we go from here? Whether it depends on whether you're on a lease agreement or on a month-to-month rental agreement. If you are on a month-to-month rental agreement and the tenant violates the lease in some way, or the rental agreement I should say, and you don't like it as a landlord, and you're on a month-to-month term, you could actually issue a 30 or a 60-day notice for the tenant to move out. It just depends on how long they've lived there. Side note, this is California. We operate based on California real estate law, so your state may be different. But if a tenant's been living there for more than 1 year and you want to get them out for whatever reason, maybe the cops were called, tenants have been complaining, and you just you need them out, 60-day notice and start the process to move them out. Okay. However, if they are under a fixed term lease, say it's month number 2 or month number 3, and they're under a 1-year lease agreement or a 2-year lease agreement, you got a ways to go. And like it or not, you're pretty much stuck with that tenant. So it's tougher to get a tenant out for violating the terms of the lease, which is why it is even more important to document the lease violations. And they could be the same thing, or they could be multiple violations, but you want to build up that file in case you ever have to do a forced eviction and you end up in court and you have to prove your case to a mediator or to a judge. Yeah, under a lease agreement, it's tougher. So if somebody was smoking, as an example, you give them a notice, or you were smoking cigarettes or marijuana in the property, boom, immediate action, give them legal notice, give them the chance to correct it, and then schedule a follow-up inspection for compliance. If you just give them the notice and hope they did, you're hoping they did, but you won't be able to verify. So the best practice, in my opinion, in my experience, is give them a notice and then schedule an inspection to follow up and make sure that it was done. Because if it was not done, boom, another violation. Now they've violated that original violation. If the tenants violate this, it's the same violation on the lease repeatedly. Smoking, as an example, and you give them a notice, and then maybe they fix it and they stop, and then they do it again, and we find out, and we give them another notice. So we start building up a file of repeated violations. They're not learning, they're not getting the clue, they don't care at that point. And that's disrespectful for the management company, disrespect to the property itself. And which really sucks is it's written into the lease agreement like 3 different times, and all the rental units are non-smoking, so no excuses on that one. If you have repeated violations, then you could pursue legal action, and at that point consult an attorney, a real estate attorney, ideally somebody who specializes with evictions, and show them the scenario, show them the paperwork, and see if you can initiate an eviction to get them out. Our lease agreement also states that repeated violations may result in the termination of tenancy. So they've already agreed to that in advance. So that works in our landlord favor, where they have been notified in writing. One of the terms of renting this property is if you have repeated violations, it may result in the termination of tenancy. So again, if they don't get it, they don't get it. Move on. So that's the good and the bad part of having a lease, is that you have a contract to receive rents, but if you want to get a tenant out, it's going to be tough. Now again, I repeating again, repeated violation for the same thing. And this is where it gets tricky. Let's say they bring in a dog that they're not supposed to have in the house. Well, you give them a violation. The lease agreement says no animals will be brought on the premises, period. And you find out that they have a dog. So now you give them a 3-day notice to cure. You are not supposed to have a dog. Within 3 days, you must remove the dog from the premises. No animals may come onto the premises, whether they belong to the tenant or not. No animals, period. It's very, very general. It does not say no dogs. It does not say no cats. It says no animals will be brought onto the premises, even if they're just visiting, okay? Just clear English, plain English. And then you give them a violation notice, and they have to get rid of the dog. Again, schedule a follow-up inspection, make sure that there's no pet odor, pet urine, damages caused by the pet, etc. Do they have a dog bowl? Do they have a dog food in the kitchen? Do they have a leash right there? Sometimes it's pretty clear when there's a pet living in the place. Sometimes it's hard because they're clean and tenants do a good job of hiding it. So you give them a notification for the pet. And then 2 months later, you find out that they were smoking. So now you give them a violation for smoking. And then you find out that, hey, they're playing loud music at night, and it's an apartment building, and the people upstairs are getting pissed off. And then so you give them a violation for noise, loud noise, and noise disturbance, disturbing the quiet enjoyment of the neighbors. Now you have repeated violations, but they're for different things. And that's where it gets tough, because now we're sort of stuck with this tenant and just building up a case. But they're not getting it, but they're also not doing the same repeated violation. So that's where it gets tricky. At some point, you just decide under a lease term, we're not going to renew the lease. So we're stuck with them until the end of the term. But when that lease is finally up, they must move out, and that's it. You issue a non-renewal, a notice of non-renewal. Now, thankfully, in the past 5 years, I could only think of maybe three tenants who have gone through my screening process. I move them in, and I determine during the time that they're living there, either they're slobs, they're just really, really dirty, excessive wear and tear. They not taking care of the property, brought in pets who were not supposed to be there. They moved in other people who were not approved to live in there, so that's subleasing, subletting, or drugs or marijuana or things like that. Probably only 3 that I could think of over the course of the past 5 years, and I manage a lot of properties, so it's not very common with the quality tenants that we get. So I'm very thankful for that. That's the point of that. But at some point, you just decide we're not going to renew their lease. When the lease is up, they are out of here. So it's a step before eviction. It's not a formal eviction. So in the past 5 years, I have not had a formal eviction that has to go to court or we have to get the sheriff involved. So very, very thankful for that. We just, under a lease, hey, when they're done, they're out, and we'll start over, get the property cleaned up and find new tenants. And that's just the game. So thank you very much for watching. It's Chris Sanchez with Sonoma Views. I'll have links on this page. If you'd like to learn more about real estate or property management, then you could go through the website and see what we're all about. Thanks for watching.